Hi, good afternoon, good evening, everyone. Buenos dias to our friends in Latin America. My name is Koldo Kasla. I'm a lecturer in the School of Law and the Human Rights Center of the University of Essex. And it is my pleasure to chair this event today. This is the first Human Rights Speakers Series event of the University of Essex this academic term. For future events, make sure that you follow us on social media and also check our events page on our website. And every week or so, we will have a number of events on different human rights related issues on topics around the world. And the first one is with this exceptional panel today, Magdalena Sepúlveda, Sandy Liebenberg, and Pedro Cisterna. And they will talk to you about social rights in Chile's constitutional moment. I should say, by the way, that this event is being live streamed on YouTube. Social rights are very much part of the core of the debates on Chile's constitutional reform. Chile is going through a fascinating time, has been going through a fascinating time for the last 2 years, really. Chile has a constitution since 1980, for those of you who are not necessarily familiar. Has a constitution that does not recognize social rights as recognized in international law, and also that includes and has included for a number of years a number of hurdles that made legal and constitutional changes difficult. And now, since 2019, Chile is going through a fascinating time of constitutional reform, where social rights are very much part of the debate. And our speakers are going to tell us about the significance of this process. In the context of this process of constitutional reform, in this unique constitutional moment that Chile is going through, the University of Essex, the Human Rights Center of the University of Essex, together with the University of Concepción in Chile, and the Global Initiative for Economic, Social and Cultural Rights, have been collaborating for more than a year and a half now, trying to identify good practices from international law and comparative practice that could illuminate the process in Chile. So trying to look at how other countries have recognized social rights, environmental rights, economic rights in their constitutions, in their legislation, and trying to see what we can learn from those experiences that can inform the process in Chile. Last month, we published the first outcome of that process. We published a book that is freely accessible for everyone. It was posted, it's available on our website. I will provide the link shortly. And the book is published in Spanish at the moment, but we're working on a translation in English of some of these chapters, at least, and it will be available in a few months. But the book is freely accessible in Spanish at the moment. It contains 33 chapters with more than 50 authors, including the ones who are here with you today, the panelists. In addition to this collaboration, the book is accessible, and also I want to mention that there is a blog that introduces the publication, and it will be also posted here in the chat for you. So the speakers today are Dr. Magdalena Sepúlveda, who is the Executive Director of the Global Initiative for Economic, Social and Cultural Rights. And Magdalena was, between 2008 and 2014, the UN Special Rapporteur on Extreme Poverty and Human Rights. Secondly, we have Professor Sandra Liebenberg, who is Oppenheimer Chair in the Human Rights Law at the Law Faculty of Stellenbosch University in South Africa. She was formerly chair of the Technical Committee advising the Constitutional Assembly on the Bill of Rights in South Africa's post-apartheid constitution. She is also a former member and vice chair of the UN Committee on Economic, Social and Cultural Rights between 2016 and 2020. And finally, we have Pedro Cisterna Gaete. Pedro is a lawyer, and he's a PhD candidate in law at the University of Edinburgh. Pedro is also a research assistant in law, climate change and environment at the University of Concepción in Chile. Each one of them is going to have about 15 minutes, and they're going to cover a range of topics that have to do with this topic of the day, this discussion of the day on social rights and Chile's constitutional movement. Magdalena is going to start with some discussion about the significance of this international collaboration, and also to reflecting about the opportunities and challenges to bring economic, social, cultural, and environmental rights home in Chile. Secondly, Sandra will talk about will provide her perspective from international and comparative perspectives, given her experience in South Africa and also the UN Committee on Economic, Social, and Cultural Rights. And finally, Pedro will bring us back to Chile and will share his views about where we are in Chile's constitutional process, how we got here, and what may happen in the coming months. So without further ado, I will pass the microphone now to Magdalena, and thanks very much.
Thank you very much, Koldo. It's a pleasure to be here. It has been a pleasure to work with the University of Concepcion and University of Essex on these books in Spanish and in English. I'm going to start trying to first put a little bit this into context and try to explain how we got here, because this is very related to ESG rights. So as all you know, in October 2019, there was a massive social unrest in Chile, an unrest that we have not been seen before since the transition to democracy in 1990. The protest included massive rallies across the country. In order to provide a solution to this institutional problem, most political parties agree and set a calendar for a new constitution. So the current constitution, and this is very important to say, it is the 1980 constitution that was drafted during the Pinochet regime between 1973 and 1990, and adopted without any guarantee. So in a state of emergency, without any mechanisms to review the electoral process, because we were under the Pinochet and the dictator, the civic military regime in Chile. And this constitution led to an overrepresentation of the political elites of the right. And there was a lot of discussion and there was very little ESG rights in that constitution. And this Chilean awakening need to be understood on the context of the inequalities of the countries. So Latin America is one of the most unequal countries in the world.
Magdalena, you're on mute at the moment.
Apologies for that. So I was saying that we have to understand the process or what happened in Chile in the context of the inequalities in the country. Latin America is one of the most unregioned regions in the world, and Chile is one of the most unequal countries. All these inequalities actually exacerbated during COVID. So this is very important to keep in mind. ESG rights has been the demand of the Chilean population for 3 decades right now. And this was very well and very explicitly put by the sentiment on the street. For many people outside, they thought that the Chilean awakening happened because of the increase in few cents of a dollar of the metro fare, the subway fare in the capital Santiago. But the sentiment on the street was very clear in saying it's not about 30 pesos, it's about 30 years. And this is really quite important. For decades, there's been social demands about a dignified life that is being understood at the need of enshrine and protect the right to health, the right to housing, the right to social protection or social security in the country. And these demands come first in 2011 with students' movements around the country. Then we have other movements that were for the protection of the environment, Patagonians Without Dam, And then we have other very important social movements regarding the protection of social protection that was against the privatized system that it was established during the Pinochet regime. During the second term of President Bachelet, there was also an attempt to have a change in the constitution, and in all the mechanisms that were there in order to provide participation, the demands of the population were about economic, social, and cultural rights. So here we are now, after 2 years of that this decision, or almost 2 years, in which this decision of writing a new constitution was taken. The COVID, the pandemic delayed the process, but we're here. 155 members of the Constitutional Convention were elected. This Constitutional Convention has very innovative systems, and this is also important to stress. So we have certain features to ensure popular representation. And I think that more prominently, it is a representation of independent candidates. There is gender parity, and there is seats reserved for indigenous peoples. So, and these all are completely new features in Chile. So we are here at the Constitutional Convention, just starting this week, the substantive discussion on the content of the Constitution. And this initiative of the two universities and the global initiative, in which we had 55 experts from around the world, national and international, to contribute, is really to bring the evidence back, is to try to provide a tool for the members of the Constitutional Assembly to find what is the latest evidence, what we can learn from other processes in order to enshrine ESG rights in the Constitution. But it's also an instrument for civil society, for those civil society members of organizations or movements that wants to really provide initiatives, provide ideas, improve the ideas and the proposals that are in the book. The book tried to do that. So the book goes into all the major ESG rights, and we learn how what is the latest discussion on these rights in modern constitutions. And we also learn how in other processes, like in Colombia or in South Africa, we also have lessons to learn to bring back here. So I just want to finalize by saying that the link is going to be there. The Spanish book, it's already available, and I invite those who speak Spanish to look at it. And I think that it is an historical moment. Every constitutional process, it is a historical moment. So we are learning from other processes to bring it here. There is the sense of hope. We really expect that Chile will improve the constitutional framework, that the social demands of the population are going to be finally enshrined in the constitution, and that at that moment, as soon as we get a new constitution that is progressive, it's going to be just the beginning. Because what we want to see, the constitution is not the final goal. What we want to see is that after a constitution is approved, we're going to start having public policies that implement these rights and tackle the asymmetries of powers that have exacerbated inequality in the country. Thank you very much, Koldo.
Thank you. Thanks very much, Magdalena. The links are already in the chat for all of you who want to take a look. I'd also take opportunity to say, if anyone in the audience wants to ask a question or make a comment, you have the Q&A function at the bottom of Zoom. There's a function there that says Q&A, and use it for your questions either now or later on, and we will have plenty of time to ask our panelists about it. So Sandy, you go next.
Thanks very much, Koldo, and it's such a privilege to be part of this exciting process, and I'm very honored to be invited to share this panel also with Magdalena and Pedro. So the process that Magdalena has described of the Chilean constitutional process comes at a very historic global juncture that we face at the moment, where there are intersecting challenges of rampant global inequalities, wealth and income inequalities. We face the massive privatization of many former public services in areas of health, education, etc., and the profound challenges to the world of work by the fourth industrial revolution, and of course the existential challenge of climate change and environmental degradation. And of course, the COVID pandemic has shone this bright, cold light on all our collective failures to realize social rights. So within countries, we see that the poor and marginalized have borne the brunt of the COVID pandemic, with healthcare services having been eroded in many countries across the world, and many social protection systems are really a threadbare system. And between countries, we see the global north proceeding with vaccinating very young children, while only 2.8% of the population in low-income countries having received at least one dose of the vaccination. So in this context, I think Chile faces this existential historical moment of how to frame a constitution that is a departure from the old classical liberal models and even the new wave of global South constitutions in the 1990s, which incorporated social rights, of which South Africa is a part, to really respond to this new, almost fourth wave of challenges that I've sketched. And I want to say that really it's a moment to reimagine our human rights doctrines, our institutions, and mechanisms. And I'll just give you one example from the field of social rights doctrine. So there's been an enormous amount of scholarship on the notion of minimum core obligations and social protection floors as being the base from which the progressive realization of social rights must proceed, but very little comparative attention to maximum thresholds of wealth accumulation, of economic growth, of consumption, which are necessary to stay within safe planetary boundaries, but also to avoid, the burgeoning economic inequalities that we face. And there is now a very well-established body of literature to show that in highly unequal societies, political influence is captured by small elites who are in turn able to block progressive social policies, and that highly unequal societies have the poor outcomes in terms of life expectancy, the intergenerational transmission of poverty, violence, including gender-based violence, and many other social indicators. So my plea is really that Chile has this opportunity also not only to include social rights in its constitution, but to reimagine social rights in a way that also takes seriously the notion of planetary boundaries and global inequalities. And perhaps in question time, we can discuss a little bit more some thoughts in that direction. But I want to proceed to elaborate briefly on these themes in the South African context, which is the context that my contribution, my chapter in this collection deals with. Because in 1996, when the South African Constitution was adopted, it was also a moment of profound hope and optimism. It was the post-apartheid Constitution. It moved us from a system of parliamentary sovereignty through which the apartheid system was enacted to a constitutional democracy. It included justiciable social rights, provisions on land rights, land restitution and redistribution, as well as environmental rights, recognizing the rights of current and future generations. And it was really hoped that this would constitute the legal foundations for the transformation of South African society from one of injustice to one of social justice and an improved quality of life for all. So it's over 25 years now of practice and implementation of this constitution. And it's a good and apt moment for stock taking on what the so-called lessons learned have been in this context. So my chapter describes how the social rights provisions in the Constitution have opened a number of avenues or possibilities for new laws and policies, for civil society campaigns, for court cases, and it also gives some of the highlights of what has been achieved in that regard. But it also highlights some of the disillusionment and disappointments. The fact that over 25 years later, like Chile, but worse than Chile, South Africa has the highest levels of income and wealth inequality in the world, staggering levels of poverty, deep levels of unemployment, with the expanded rate going up to 40% of unemployment, and very deep systemic problems of corruption and maladministration. So the South African experience really is that we need to reflect on, to pick up on a theme I've already mentioned, how the redistributive potential of social rights can be harnessed much more to address economic inequality. So in the South African context, recent studies have shown that the top 10% of the population owns more than 85% of the total wealth in the country. And the bottom part of the wealth pyramid is dominated by Black people and particularly Black women. This is both due to the legacy of the colonial and apartheid policies, but also as the UN Committee on Economic and Social Rights has recognized in its review of South Africa that the economic policies of the post-apartheid period have been insufficiently redistributive. And despite having the basis to argue for greater economic inequality through our strong substantive equality clause combined with social rights, there has not really been sustained attention to framing economic inequality as a human rights issue in South Africa. For example, our Human Rights Commission has paid a lot of attention to poverty and deprivation of social rights, but relatively little attention to economic inequality. And linked to this is the fact that although the South African Constitution makes provision for the rights to apply to private parties, so private businesses and landlords and insurance companies, etc., and we've seen, you know, a lot of positive developments in the area of property law, where property rights have been limited to protect the housing rights of people without access to housing or facing eviction from private property. There hasn't been a corresponding development in the areas of the law of contract or the law of commercial law doctrines, and many of these doctrines actually sustain the inequalities and environmental degradation that we see. So it's really important that emphasis is given to the application of these rights to private actors, but also that the law governing the law of contracts and commercial law, etc., should develop to reflect the values and purposes of social rights. And then the second point I will make here is related to the design of institutions to implement, monitor, and hold accountable various actors for social rights. So I think one of the areas where, in retrospect, South Africa did not pay sufficient attention was in the area of economic policy design in the Constitution. So we have social rights in the Bill of Rights, but then Chapter 13, which deals with the policy, economic policy and budgeting process and the distribution of resources, is silent on the kind of principles that should apply in this context. And this issue has really come to light in the COVID pandemic, where South Africa embarked on a policy of fiscal consolidation or austerity, ironically enough, which is having a severe negative impact on social rights and promises to have that going forward. And this has been in an attempt to rein in, you know, what is regarded as unsustainable levels of sovereign debt by the South African government. So I think the question of how to deal with economic policy to ensure that it's aligned to the values of social rights and economic inequality, and also, for example, making provision that the budget should incorporate a human rights impact assessment, environmental impact assessments, and that there are systemic measures to ensure that social rights are incorporated. It's a mistake simply to rely on the courts. Much can be achieved, but we should certainly not put all our eggs in that basket, because there are institutional limitations to what can be achieved. And the same also applies to environmental rights. I mentioned our progressive environmental rights clause, which recognizes a healthy environment, ecologically sustainable development, the rights of present and future generations. There's been progressive court cases. So our High Court, for example, has prevented our National Minister of Environmental Affairs from going ahead with new coal-fired power stations without a climate change impact assessment. There have been cases which have also emphasized that, you know, local communities must give their consent consent for mining activities on their traditional lands. So much progressive jurisprudence, but the systemic problems of South Africa being a highly coal-driven economy, coal-dependent economy, that we are still very much, we are the 12th highest emitter of greenhouse gases in the world. These are still very much present. And it speaks to, I think, what my message is, that we need to adopt a systems approach and think of social rights across governance systems, across private law systems, to ensure that they really have a more systemic impact, including also within political party manifestos and campaigns. And then just finally to say that we also need to think about innovative monitoring mechanisms. So for example, one innovative mechanism would be an ombud for future generations, such as Wales has, I understand, which can really also complement the role of the courts and the role of civil society. So in conclusion then, as I've said, that Chile has this historic moment to design a constitution that can respond to these interlinked crises of poverty, inequality, ecological degradation, and that in doing so, they can draw lessons from other countries such as South Africa. But also my message would be that the Chilean people and the Constitutional Convention should not be afraid to reimagine the constitutional architecture of Chile to achieve a just, inclusive, and environmentally sustainable society and economy going forward. Thanks, Caldo.
Thanks very much, Sandy. There is a lot of substance there in your contribution. I really like your appeal, not only to incorporate human rights, but also to reimagine human rights. And I'm sure that your proposition about maximum thresholds of human rights, not only talking about the minimum core obligations, but also talking about what is the maximum that we can tolerate of inequality for society to flourish. That is certainly a challenge for the human rights community, and I really like the challenge that you posed there. I'm sure the participants will also have a lot to reflect on later on. Finally, we have Pedro Cisterna, who is, I understand, going to bring back the discussion back to Chile. He's going to reflect about where we are at the moment, how is it that we got here, and what do you think is going to happen in the months ahead. So, Pedro?
Yeah, well, thank you, Caldo, for the introduction. And well, first, I would like to thank the Center of Human Rights of the University of Essex for organizing this event. And for me also, it is a great pleasure to share thoughts with these two brilliant colleagues, Magdalena and Sandri. And also, I'm very happy to launch this book. I think it was a huge and nice collaborative work between the Law, Environment, and Climate Change program of the University of Concepcion, the Center of Human Rights of the University of Essex, the Global Initiative of Social and Economic Cultural Rights, and the European Studies program of the University of Concepcion. So I think this kind of collaboration is essential to face this global challenge that we have in human rights, but also in other areas of law. And well, my presentation is very, I'd say, simple. I would like to contribute by talking about how the Chilean people gained the opportunity to write a new constitution, a democratic one. Also, I will make some brief points about the current work of the Constitutional Convention, and finally some comments about the challenges that this process, I think, we have in the near future. So how we get here? Well, Magdalena made really relevant points about the process that Chile had during the last decades, and I would like to add a couple of things. And also, well, in my opinion, the beginning of this process didn't start at the 18th of October of 2019, which marks the social unrest. Obviously, it's related to some social movement demonstrations in fields of education, social security, health, housing, as Magdalena pointed. But basically, all these processes reflected that this social explosion was also the result of a broader social process related to the conscience that the people in Chile was gaining every year about the inequalities created by a neoliberal system that was imposed by a dictatorship. And I think this is very the result that a neoliberal system in the more extreme way can have in every country, in any other country. And in this sense, I would like to recommend one of the articles of the book, Podolaski, Smart, and Fernandez in the volume 1, chapter 2, I think. Which it's a really good diagnosis of the situation, of the inequality situation, the inequality and injustice situation that Chile was living. But also, it is curious, but for another part of the country, Chile was really good. I mean, Chile was a nice country. Chile was an emerging economy in the world, was part of the OECD. A couple of weeks ago, the social unrest of the 18th of October 2019, the President, Sebastián Piñera, said that Chile was an oasis within Latin America. So basically, I think that declaration reflects the difference, how different was the country for different people. And I think that is the key issue, that our development, that is the key gap that of our development, social development, environmental development has in our society. The different understanding, different ways that the people live is something that marks the understanding of and the opinion that we have about the system. So I think certainly the 18th of October is a milestone in this process, and the 25th of October as well of 2019, where more than 1 million people gathered at the Plaza Dignidad or Plaza Italia in Santiago. But regrettably, and I think that this is very related to human rights, regrettably, the answer of the government was repression. So, and that is something that it is really interesting to research and to think about it. Why that kind of violent response from the government to peaceful demonstrations? More than 400 people had eye injuries after the repression in Chile, and even some of them lost their vision, like Gustavo Gatica in Santiago. So this brutal repression didn't stop the social movements during these weeks. Basically, there was a real Chilean awakening. In not only in Chile, also Chileans across the world. I was living in Edinburgh. I mean, I'm living in Edinburgh, and I was in Edinburgh by that time, and I obviously joined some demonstrations here in the UK as well. So this confrontational context was the background of a political agreement that basically gave the solution to have a referendum. In my opinion, that is a very positive step for the Chilean society. to vote for a new constitution. The victory was indisputable. 80% of the population voted in favor of a new constitution and in favor of a popular elected organ to write the new constitution. So I think that is really relevant to consider as well. And also that, as Magdalena also as well noticed, that we have a gender parity constitutional convention, and 17 of the 155 representatives are from indigenous populations. Which is very relevant, because these groups in Chile historically have been oppressed and segregated from the political decision making. So, having said that, obviously this is a very good news for the Chilean people. It has obviously conflicts. There are opposition as well, but the Constitutional Convention, it was basically installed 4th of July, and the first task that this Constitutional Convention had was to agree a statute for the functioning of the convention. So procedural rules and the structural organization of the organ, and also establishing communities. But it is interesting that if we read the statute of the convention, there are also principles such as the territorial equity, public participation, and also an ecological approach, which basically seeks to orient the discussion, the substantive discussion that the Constitution will have, and I think that is really relevant. Also, the statute established 7 committees on fundamental rights, for example, on environment, and I have to say that the structure of this book is very useful it's a very useful contribution to follow the discussion, because many of the topics that were described in the statute that the committees will have to discuss are part of the book, which I think it's nice to know, and I think it will be a useful document for the civil society, but also the representatives in the Constitutional Convention. So finally, I would like to point a couple of challenges for me and from my academic field. My academic field is environmental and climate law, and I think a major challenge of this new constitution is the incorporation of the climate crisis as a factor for the enjoyment and guarantee of human rights. I think climate emergency and its impacts influence all of the ambits that the new constitution will regulate. Our institutions and rules should be adapted to the climate crisis, and I believe that the current constitutional discussion is a great opportunity to write a constitutional text that understands the challenge of climate change, and it incorporates this into rules and constitutional rules. And I have a critique there, because currently the only committee that have the constitutional crisis as a topic to discuss is the Committee on Environment, which, in my opinion, I will give a broader approach and a more transversal character for the climate discussion. I think it is important to include the climate crisis in other ambits of the discussion, of the constitutional discussion. For example, it would be interesting to include the principle of intergenerational equity, which is very related to climate change, but also can be applied in several other ambits of the Constitution. And the other one that I think the other challenge that this is a more procedural challenge that the Constitutional Convention has is that even when the people was elected, the people elected the representatives of the Constitutional Assembly, it is important that the Assembly continue having contact and hearings with communities. This territorial equity principle should be applied by the Constitutional Convention. Last week, representatives had a territorial week where most of them created collective forums for talk about discussions and further advancements of the Constitutional Assembly, which is nice, which is positive. I think it is the way to continue engaging the population. And also in terms of decentralization, the Constitutional Assembly these 2 weeks, for example, will take place in Biobío region in the south of Chile. Which also illustrates a good approach for public participation and decentralization. But I think this needs to continue broader, because it's one of the probably best ways to legitimize the future tax within the population. So those are my comments. Thank you again for the invitation, and I'm happy to answer questions and comments.
Thank you. Thanks very much, Pedro. And I think this is an excellent way of giving way to 2 questions that I want to pose to the panel, if I may. The first one comes from me and from Mirza Adi, who is in the audience. And the question is this. I want to bring politics back to the discussion, if I may. I think one of the reasons why the Chilean case is so interesting is because it challenges this assumption that we've been hearing for years, that in this moment of populist uprising, either you are for human rights or you are for democracy. This is a discourse that we've been hearing in a number of countries of an illiberal democracy, of people supporting leaders that do not support human rights. And the human rights community at times has been forced to choose, or there has been a discourse that has created this dynamic in which you feel you have to choose between defending certain principles based on human rights or defending the will of the people. And I think it's a fake choice, it's a fake dilemma, but it has been presented as such, and we've been seeing it in a number of countries, certainly in the country where we are based at the University of Essex. And I think Chile and what's going on in Chile breaks that false dilemma, because it shows that human rights can also represent the will of the people, and it emerges from the bottom up. So I want to ask you, the first question, mostly for Magdalena and Pedro, but Sandy, by all means, feel free to jump in as well. I want to ask you about what do you think is going to happen in political terms in Chile? There is a presidential election coming up next month. The election to the Constitutional Convention back in May showed a huge majority for the Progressive Front and a minority for conservative right-wing politicians, as I understand it. Would that be enough to prevent some sort of minority blockage to progressive agenda recognition of social rights? Do you think it's going to go far in that regard? And the question that Mirza asks is how the right-wing politicians respond to the discussion of recognizing social rights in the Constitution. So that's a little bit the first part of the question about Chile. And then for Sandy, I have a question here from Jackie Dugard, also in the audience. So the question is, many thanks for this excellent seminar. I totally agree with Sandy's points that it's essential to connect budgeting and planning with economic social rights, and that this doesn't happen in South Africa. None of our budgets, she says, look at how to achieve the minimum core, let alone progressively realize economic and social rights. How could this be better institutionalized, you think? Who wants to go first?
I can go first, and actually, by going first, I'm going to refer the political discussion to Pedro, and I want to bring back a more technical issue. So, because your question is also linked to the issue of legitimacy, and we need a constitution that is legitimate. I mean, what the whole process started because we're challenging a constitution that is completely illegitimate in the way in which it was adopted, who was the constitutional power, etc. And I think that if we go back, for example, to Thomas Frank, he says that the legitimacy depends on the rule and the rule making. So we have to separate. So for our constitution to be legitimate, we need a constitution that, as I said before, needs to reflect the demands of the people in Chile. And those demands, as I try to emphasize in my presentation, are completely linked to this indivisibility of rights. This demands of a life in dignity, that is the sentiment in the street, refers to a life in which the ESC rights are satisfied, and there is and you tackle sort of structural inequalities. So and that is a process that then requires a referendum. You need a 2/3 of the population, I mean, in the process. You need the 2/3 within the rule making to approve that, and then you need a referendum to legitimize that. But we also need the process has to be legitimate, and this is something related to what Pedro said. So, if the territorial equity is a principle, democracy and participation should also be key. So even though the conventionals has been, the members of the Constitutional Assembly, they have been elected, it is critical that they keep all the channels open for the broadest participation possible from civil society, for social movements, from individuals to come into the constitutional process. So basically, we're going to have a legitimate constitution if the process that we're having now and the Constitutional Assembly keep these doors open for a broader participation, and they follow the rules that they have established and the principles that Pedro just mentioned. And then we also need that the substantive content of this constitution enshrine what Sandy referred before. It has to be a systemic approach. And this is critical. And why this is critical? Because we have seen some other constitutional process, in particular in the region, in Latin America, in which you have even very, that some rights are enshrined in a very poetic manner, if you want, very progressive, very poetic, but that is not enough. So you can have, and it's necessary to enshrine ESC rights, for example, and they have to be enshrined in a correct and an appropriate way, but that is not enough. We have to have the rest of the Constitution to be aligned with that. We have to have territorial decentralization in the country. We have to have that municipalities have the power to satisfy the needs of the people at the very local level, at the level of the municipality. We have to have mechanisms to allow for these rights to be demanded in court. And we also have to have all the other systems of law that will push for the translation of these rights in public policies. And fiscal policies and the economic aspect of the Constitution, as Sandy mentioned before, is also critical. So we also need, and this is critical in the context of the Chilean Constitution, of what we have now, we need to have this into account. And luckily, in the 2000, in the period that we are now, in this decade, it's evident that fiscal policies and human rights are linked, and that you can establish fiscal policies that are aligned with certain economic system and at the same time comply with human rights. And that is also what is required in our Constitution. And finally, is the issue of gender equality, and that is essential in the country. So these inequalities, of course, are intersected by race, by ethnic origin and by gender and by sexual orientation and by many other ways in which certain groups in Chile has been historically and systematically discriminated against. So it is very important. I mean, Chile doesn't recognize in our constitution until now that the plurality of the country. We don't recognize our indigenous people. This is the time in which we have to recognize, and that is very exceptional in Latin America. So we have to recognize where we are coming from and our indigenous peoples, but we also have to recognize and make huge efforts to bridge the gender gap in Chile. And the gender gap, you can see it, it's so evident in the enjoyment of all ESG rights. From pension, that women receive considerably less than men because of the reproductive role, but also from the enjoyment of many other rights, that there is even the right to access health. In this privatized system, women, again, due to their reproductive rights, as this work as a private insurance, as you can imagine, is much more expensive for women to have access to health than for men. So the system, it's really, there is a huge gender inequality that it has to be confronted head on, otherwise we're not going to move. And that means, again, not only a beautiful clause saying that men and women and have equality and the provision of discrimination on gender that for other gender identities is also critical, but it has to be the whole system of the constitution that have to lead here. So I left the most difficult part of the political party to Pedro, but what I want to say is that it's the process and it's the content what is needed now, and they have to be legitimate and they have to respond to these demands.
Thanks very much, Magdalena. There was a lot of substance there in your response, but it's true that you passed on the hot potato to Pedro. So, Pedro, would you go next about the politics of the situation?
Well, yeah, very difficult to answer, but I will try it. So, I would like to organize my response in two parts. For the first, regarding the answer of the right-wing government. And I think here there are two aspects that for the right wing and the right-wing government are difficult to deal with it. So first, full public participation. I think historically the right wing in Chile tried to avoid and restrict any space of public participation in any kind of decision, from political decision, environmental decisions. So we are now seeing a process that where public participation is essential as a human right, but also as a procedural aspect. So I think, in my opinion, it is important for the Constitutional Convention to learn and to consider the experience, the practical experience of fields like environmental law, public participation, and the principle 10 of the Rio Declaration. How this kind of practices have been applied not only in Chile but also in other countries in similar process, to learn more about the substance of this kind of process, and I think that is a good way to overcome the opposition to participation from the right wing, and that is also expressed in the first debate that in the 15th of November, where the political agreement in 2019, where the political agreement was taken. The right wing basically they wanted a new constitution, but written by the Congress, so no participation at all from the people. So I think this tension will continue all the time, and we need to put some effort in implementing this principles there that have standards, human rights standards that have experience. So this legal knowledge should be put in place to advance in a more substantive arguments against this kind of opposition. That's one thing in this first part of the answer. And the other one is I think another huge opposition. I mean, or an issue that probably will appear is regarding property law. I think property law is one of the big tasks, and property is also human rights. So the discussion is very sensitive, because those who defend this individual and notion of property use human rights as an argument. But at the same time, basically the discussion today is who is the owner, whatever we are talking. For example, regarding water in Chile, water is based on a private property system. So who is the owner? But the discussion also needs to approach what ownership means. What is the meaning of ownership? What we need to do with the resources? So I think this discussion will take place in several ambits of the substantive process that is happening right now, and I think the incorporation of human rights standards is essential to deal with these discussions, even when the more than two-thirds of the representatives of the Constitutional Convention probably agree on a more progressive vision of property. But the thing is how to involve in that discussion to the public, and that is related to what Magdalena pointed. So that is a huge challenge, I think. And finally, if I have time.
Yeah, go ahead.
Yeah, so another, I think, just answering the question of Koldo about human rights, and how human rights can be used in this process. So historically, the perspective of human rights in Chile is very related to the process of the struggles against this dictatorship. So all the human rights were basically in the I'm thinking in the public opinion, if you talk with it. So everyone relates human rights to defend people from the police repression, or the abuses of the dictatorship. But now it is nice to have. It is a great opportunity to amplify the notion of human rights within the population. I mean, in the population, and that is a really useful way to understand human rights and to propagate the human rights in the public participation of the people in the process, because now we are talking more about the human right to environment, the right to housing. So other aspects of human rights are now not only in the discussion of academic or political elite, but also in the conversation of the people, which I think is something that we need to stress more and more and more. So human rights there are really, really relevant.
That's very good to hear. It seems a very informative moment. And later on, I want to ask you, all three of you, about this issue of property and the relationship between right to property and other human rights. But I would like to hear from Sandy, indeed, about anything that Magdalena and Pedro have just said, but also otherwise about the question posed by Jackie in the chat.
Thanks, Caldo. So, I mean, I'll just have a brief observation on your question on the tension between democracy, liberal democracy, and human rights in this context, not specifically with regard to Chile, but, you know, just to note that it is often also a false binary in that democracy is also constituted and created, you know, by organizations. So, I mean, I think a lot of the populism that one sees in the US and around the world is, you know, often due to a failure of left-based organizations, you know, to mobilize and not convert, but to actually mobilize into non-traditional constituencies. And this has been, you know, one of the great sort of scourges of neoliberalism, is that the traditional organizations of the left, like trade unions, have really been decimated by, you know, the sort of gig economy and, you know, so forth. So I think what's hopeful about the Chile process is, you know, this bottom up, you know, calls, this organization, this mobilization. But I think it's also, South Africa also had this at its constitutional moment. But I think as we think about norms and institutions, you know, I think equal thought should go into sustaining, how to sustain that energy and popular mobilization going forward, because that creates the living constitution on which the realization of the written constitution will depend. And then, yes, Jackie's point about macroeconomics and human rights, I think this is exactly where Chile does have this opportunity that we did not take when we drafted our constitution. You know, I mean, we also organized the process into different theme committees, with one dealing with the Bill of Rights, and one dealing with finance, and one dealing with intergovernmental relations. And I think that systems approach then meant that often we lost opportunities to integrate human rights provisions into macroeconomic policy. So there's no reason why the Chilean constitutional process couldn't require in the constitution human rights-based impact assessments and public participation before in the process of macroeconomic policy, as well as budgetary decision making at every level. So you institutionalize that in your highest law, which could then be used, you know, to design legislation, to actualize it, and for civil society campaigns. So I think there's a lot that can be done at the constitutional moment to, you know, actually require rights responsive economic policy and budgeting processes. And the same, you know, and to touch on the property issue, which I know you said you were going to come back to, and which is an extremely hot potato in the South African context, because, you know, part of the political settlement was that there was going to have to be a property clause in the constitution. But at the same time, there were great concerns about the impact of the property clause on the urgent need to redistribute land and wealth in the country, and, you know, particularly if the requirement for expropriation of property would be market-orientated compensation. So the South African constitution tries to create a balance, you know, with market value of the land again been only one factor to take into account alongside the current use of the property, the history of the acquisition of the property, and many other factors. And as I mentioned, there's strong provisions on land reform. But the political class has now argued and blamed the property clause on the Constitution for the very slow pace of land redistribution in South Africa. And there's a process underway to attempt to amend the Constitution to provide for nil compensation for expropriation of property, but it seems doubtful whether the 2/3 majority will be obtained for that. But it does raise, you know, very, very sort of difficult issues about the property clause and its relation to redistribution. And I mean, just to touch on the point of Andrew Fagan in the chat, you know, about whether economic inequality is too big an ask in a constitution, I think as a minimum, what one can do is to ensure that the way, you know, if Chile's new constitution is going to have a property clause, to ensure that it's drafted in a way that doesn't prevent redistributive measures or social policy measures such as imposing land ceilings or ceilings on land ownership to achieve more equality in the distribution of goods and services. So I think certainly there's a lot that can be done, also to require, you know, tax policies to be progressive, you know, to ensure that tax policies allow, you know, sort of for a progressive redistribution of wealth. So I think there are things that can be done within a constitution to address economic policy and integrating human rights in budgetary decisions. Thanks, Cole.
Thank you, Sandy. That was actually the question that I was going to present to you, all three of you, next. The question from Dr. Andrew Fagan, who is the director of Essex Human Rights Centre, about really the relationship between socioeconomic inequality and human rights, and whether human rights are well equipped to deal with the challenge of inequality, whether they are fit for purpose, or whether perhaps we are over-promising, perhaps, and under-delivering when we say that human rights can address inequalities. And that's the question I would like to pose to the three of you, connecting also with the question presented by Heine Fechner. And the question is, do you think the question of economic thresholds could or even should be linked to economic and cultural thresholds, or media concentration, or the need to democratize the media? And I will, before I present these two questions to you, add a reflection on the poverty, on the property, not poverty, on the property issue. And is, how do you think, and Sandy has touched on this already, but how do you think that we should conceptualize the right to property if we take economic and social rights seriously? So, for example, the Chilean Constitution 1980, and I believe the previous one, 1925, includes, as many constitutions do, the idea of social function of property. But this notion of social function in Chile and in many other countries is interpreted in a very minimalist way, giving property owners a lot of power and people who use social function a very, very limited threshold to democratize the use of power, to provide some sort of social responsibility to landowners and large landlords and so on. So what do you think, relating to inequality, media control, what do you think should be how we reimagine the idea of private property, the right to private property, taking socioeconomic rights seriously? Who would like to kickstart this? Magdalena, please.
I can go. In terms of inequality and ESG rights, I think that the studies of Professor Sakiko Fukuda in terms of reviewing constitutions and protections of ESG rights in constitution, and then the levels of inequality, are very telling. So there is a direct correlation between the less you enshrine ESG rights in your constitution, the most unequal society you are. And I'm going to more or less at this moment leave it there to go to your very difficult question about the right to property. The right to property, it's one of the more controversial and complex human rights, but it's also one of the human rights that has more qualification and limitations. And that is why the sort of the case law that we see in terms of the right to property, it varies and it's very comprehensive because of the complexities of this right. But on top of that, I should say that in Chile, we have seen something very different. So we don't even need to look at the text of the 1980 Constitution, because actually what the Constitution says in regard to certain aspects of the right to property are, and as you pointed out correctly, Koslo, are interpreted completely different, because we have a set of constitutional laws, leyes orgánicas constitucionales. These are laws that were created to really develop and tie the Constitution. So actually, Jaime Guzmán, who was one of the ideologists of the Constitution, he was from very close to Pinochet, and he was one of the constitutional professors that created the Constitution, and in all this commission, he said, and this is also very telling, that he was writing a constitution that if the political forces change afterwards, they will need to keep the economic and the system that it was established. And this was that, and he said that, and I'm not quoting him verbatim, but almost. And this is critical, because the Constitution and all these constitutional laws, in the way in which they interpret property and expropriation and doesn't allow to expropriation, it was critical. And why is this? Remember that the country was coming from a point in which Presidente Allende has nationalized some minerals, has nationalized copper in the country. And there was also a lot of discussion in the Unidad Popular, in which the direct response in the 1980 Constitution was tied everything, so not to do this again. So basically, for example, in the Constitution, we said that the mineral companies do not own the land, but actually the system that is established for expropriate any mineras, any mineral, it's not say mineral companies, how do you call it? Any, well, all these companies, it is also almost impossible. You will need to pay even for the minerals that they might not even exist in the future. So it makes this impossible. The same happened with the water. The water, I mean, we have the atrophy, and it's something horrible, but the water is completely privatized. And that is something that it's not said directly in the Constitution, but it is all systems of law that make it the water actually something that is completely private. The protection of property is the same. So this is something that, again, and talks about the way in which you, the system approach to the Constitution. So we have to have the social function in the Constitution, but a real one. What we have now, and this is critical for many rights. It's the right to property is critical for the right to work, for the right to enjoy the benefits of scientific progress. What are those discussions about the right to property and vaccine patents now? This is critical. The right to education, the right to adequate housing. So again, we cannot discuss the right to property without taking into account the Chilean context and the historical process that led to the 1980 Constitution. And in here, we need a paradigm shift in what we have in the current Constitution. We have to allow for the distribution of social goods and health and wealth, and we have to allow for stronger limits to the right to property for the common good that we don't have at this moment. We are in the just the complete opposite extreme, and even the fish. So we privatize. I mean, I think that the fact that Chile is the laboratory of the neoliberal policies, it's just people outside the country might have problems to understand that even fish are privatized. So you actually buy the quota to go and fish in the country. So everything is privatized. So we are in such an extreme in terms of the protection of the property and without any consideration of the social function and the common good that we need to completely change the system, constitutionally speaking, but all the sort of the additional laws that support that.
Thanks very much, Magdalena. Who wants to go next?
I can go. Sorry, Sandy, would you like to go as well?
No, please, Pedro, go ahead, and I'll just chip in with a few final comments there. Yeah.
Well, regarding the implementation of human rights standards within the constitutional process, I'm not an expert on that, but so I will focus more on the question of property, which I think it's related as well. So. I think that the social function of property is a huge debate in Chile, and here I would like to highlight this confrontation between because social function of property has been understood as a public law concept. Obviously, it's in the Constitution and has been understood from that, but has been totally. Differently applied by the private law, So there is a dissonance between public law and public law and private law in applying social function of property. That doesn't happen only in Chile, in other countries as well. So thinking, for example, and that is I think one of I really recommend a book of Catherine Pistor, The Code of Capital, which I think it's really relevant to understand how the way that property has been understood, not only in civil law countries, but also in common law countries, shape inequalities in our societies. So thinking in the right to adequate housing and evictions. So on one side, we have high standards of eviction, like to defend the human rights of the right to adequate housing. But on the other side, we have private law rules that basically are built in abstract notions of the law. So it's very difficult, or maybe it's a challenge for the Constitution to get a dialogue between these two notions, like different notions of property and the application of property and the right to exclude, for example. So, and I think that it is important for Chile for the Chilean process to look at another constitutional process that have had the same issues. For example, for me, it's a pleasure to share the floor with Sandy, because the South African example, it's amazing in terms of evictions and how the Constitution also encouraged to have a prevention of illegal eviction act, which basically try to connect these two notions of public law and private law and get more connection on that. And I think look at also authors like A.J. van der Walt. It is important for us in the Chilean process to look at as well. Or another institution like in Brazil, the Colectivo Sucapio, it's in the context of the right to adequate housing. It is also important to see how these innovative institutions have been applied. What is the result of this institution, which in my opinion are positive by itself, but it is important to see how they were implemented, because it is a good illustration on how this process tried to connect this notion, this private notion, this abstract private notion of property with this more practical and realistic notion of property that public law has tried to encourage. But also some authors in private law try to encourage some more realistic views of property and how we apply it. So I think in the property context, it is important to watch and to review other processes, not only in substance, but also in implementation.
Thank you, Pedro. And Sandy, you go next. I mean, if in your response you could include some final reflections, because time flies and we are approaching the end.
Yes, so I was exactly going to tie in with what Pedro mentioned, that I think the South African property clause in how it tries to balance issues of, sort of protection of property rights with the redistributive social function is interesting. If you are going to have a property clause, which I don't necessarily think, it should be a given in Chile, but I don't know the politics for that. I mean, the property is not a right in either the civil and political rights covenant or the economic and social rights, but obviously it can, as Magdalena said, help foster certain rights. But I think, as Pedro said, our court's jurisprudence on eviction has been very instrumental in sort of making inroads on this monolith of private property rights, by requiring alternative accommodation to be provided, by requiring public authorities to be joined to eviction applications so that they can facilitate alternative accommodation and resolution. And they've insisted on meaningful engagement, with those to be evicted from their land. But I think, and Jackie Dugard, who is among the panelists, has also written about this. I mean, it goes only so far, it hasn't really redressed the spatial inequalities in South Africa. It hasn't really been able to make meaningful inroads in the sort of backlog of housing. And, that again speaks to ensuring that you do, and I suppose it's like a stuck record, Magdalena and I saying this, the systems approach, that, and the redistributive approach that, many progressive scholars and decolonial scholars say, well, the social rights have only ameliorated poverty. They're having a sort of minimalist agenda of poverty alleviation, but haven't had any redistributive ambition. And that is partially, I don't think that's totally true. That's partially because the courts have, have limited powers to bring about redistribution. But if one conceptualizes social rights as being addressed to the legislature, the executive, human rights commission, society as a whole, then it can have a broader redistributive impact. So we need to think out of just the Bill of Rights box at, all other provisions. And, and I see someone mention trade and investment law in the chat. Absolutely correct. I mean, these, silos where human rights is one silo, but contract law is another, property law is was another, trade and investment, copyright law. You know, really our human rights should be the ground norm, and all other bodies of law should actually serve the values and purposes of human rights, including social rights. So there we go.
Thanks very much, Sandy, and thank you all, Magdalena, Pedro, Sandy, and indeed people who are also participants who have been asking questions and paying close attention. It has been a pleasure really to facilitate this first of a long list of human rights speakers series events that we have at Essex. I have put here the link to the next two events next week. The future of policing and mental health crisis, and 2 weeks later, litigation and climate change. How can human rights be mobilized through the courts to tackle climate injustice? Watch the space, follow us on social media, check our website to make sure you don't miss any of the coming events. Thank you very much also Sophie Conlon, who is in the background, making sure that everything works smoothly and that you can follow us and hear us also on YouTube. And thanks again, Magdalena, Pedro, and Sandy. See you next time.